they match, automatically is in. In most of the cases, millets, unfortunately, they have not taken care of the correct particulars. They've invited the trouble.
If that is so, please examine the written submissions put in the Bihar SIR
We will.
case.
We will.
It is very clear.
Millets, I take it and I'll
It's
just
not
come back
that
to your
the
lordship.
entire electorate has to upload documents. No.
Millets, no document is needed provided you are there. In 2002, those who have, yes.
Now you are
Millets,
amending your
I'll just
argument.
demonstrate in one
You
case,
are
Millets.
deviating from your original
No,
argument.
Millets, what has happened, in 2002, somebody is else there. And they have to replicate whatever was there in that one. And they,
Let's not, you are only trying to say that somebody says today that how I will excluded my name, I am there in the 2002 list. You are saying, sir, if you are there in 2002, you are welcome. But in 2002, the name is XYZ. Today you are claiming XYL.
exactly.
Therefore, the problem is right. XYZ.
That's the only discrepancy. Had they faithfully filled the forms cautiously, that the same person, they wouldn't have been, automatically they would have been allowed. What they have said is, that's my alias name.
A 2002 elector does not fill any form.
Millets, they need 2 minutes. Enumeration form is a mandatory one. Form, all that they have to do is, may I just give the practical ones which we have done, Millets? I'll show them to your lordship.
They just
So that
fill
my
up-
lords could
They
appreciate.
fill up their names.
Yes,
That is it. No
exactly. It's a ministerial job of filling up the names correctly. If they have not done that,
That is only an format without any documents. That there you disclose that, yes, I am there already in
Yes.
2002. I am not required to,
I am not required
not
to put in any
supposed-
confirmatory document.
yes, not necessary at all.
Document is
That
for
name itself is
candidate.
enough.
Now
Only
you
thing
are
is,
correct.
the details should match. There ends the matter.
Now what?
I'll just submit a model forms to your lordships. Kindly consider that. Whether there is any
You are
deviation.
submitting model form to someone who has filled up a form.
Beg your lordship's pardon.
You are submitting model form at least to me who has filled up a form. All right.
No, Millets. But the cases where they have not matched, despite their being there in 2002, once they have made a mistake in presenting the present enumeration form, that flags.
Question-
Otherwise, it's in.
That is not only the filter used in flagging logical discrepancy. There are multiple filters.
Millets.
There are multiple. That's the same. And they are born within 6 months. That sort of filters are
That's
there.
what we have called logical discrepancy, Millets.
Now,
That's what we have called logical
That's what I
discrepancy.
am bringing you.
Yes.
When you bring in this logical discrepancy, it actually invokes your constitutional powers of verification, right? That can never be taken away. It is there.
Yes.
And what you rely on, in our understanding, is section 22 of the Representation of People's Act.
Discrepancies, whatever the variations, Millets, and then based on that one, they're informed, then they can as well submit to the ERO their objections or their justification, how in that process, my lords have said, because of the inadequacy of officers, judicial officers have come into picture.
Been done because the volume of logical discrepancies which were marked and the date for the election was so close, and there was a constitutional issue of trust deficit which we pointed out. between the people given by the state inadequate?
Could my lords recollect, millets? The whole trouble began when we wanted EROs who have had this quasi-judicial experience. They were not provided.
Right.
Once we have taken,
Mr. Naidu, it is not a fight between the state and the election commission.
inadequacy of manpower, millets, I'm submitting.
It's not a blame game. It's a question of the voter being sandwiched between constitutional entities.
Millets, we have given every
When-
provision.
when-
We have given every assistance.
When we are fully in agreement with you.
Yes, millets.
From your point of view, you have put your best foot forward. From the state's point of view, they are circumspect. We have decided that in this situation, to ensure a fair and impartial election, the purpose of the court must be enabling and not a adjudicatory exercise of who is right and who is wrong.
Millets, in the orders also, your lordships have chosen the votes very carefully in a very balanced manner. Never an accusing finger, either side.
The very spirit of court's hands-off approach, and if you see Mohinder Singh Gill,
Yes, millets.
Lokhi Kantro Sen,
Yes.
each and every case, the courts have intervened to promote fair election.
Millets, we have had every endeavor.
Or interdict an election.
Yes,
And that is our spirit, which we invoked under Article 140.
Precisely, millets. Even,
Deploy officers where there was a trust deficit between the state and the constitutional entity responsible for superintendence of roads, that these judicial officers will undertake a verification. But the volume, because we were not able to give the adequate numbers, the volume at which they had to do, there is always a chance of error. Just consider, Mr. Naidu.
Yes, millets. Could my lords?
Going through 1,000 documents a day, if our correction or accurate rate is 70%, at least speaking for myself, I will rate the activity excellent.
Excellent.
So this is the pressure at which the judicial officers have worked. And so there will always be a margin of error. And in these situations, again, tested from the principles of reasonableness, due process, we need to have a robust appellate.
Yes, millets.
We need to have a robust appellate program where both parties
May I add only one thing,
can
millets?
delete and have a continuing right.
Yes.
Somewhere we are getting blinded by the dust and fury of an impending election. But a
Well, it's-
right to remain on a roll, a right to vote in the country where you are born.
Yes.
Is something which is not only constitutional, it's sentimental.
Indeed, millets.
It is the biggest expression of nationality and patriotism that you are in a participatory process.
Democracy.
to Create and elect a democratic government. So this is something which we need to very seriously.
Precisely, millets. Precisely. We have given statistics, millets, involving all states that have been subject to SIR.
Please help.
The exclusion or inclusion, we have given the
Please help
percentage.
us
West Bengal doesn't stand out in any manner. It's been on a par with many other states.
Really, sir.
And only question is
are-
that,
you
my lords,
are-
with
you
regard
are
to
at-
manpower, my lords have come to our rescue.
We are not bothered about West Bengal standing out or West Bengal
It's been on a par, my lords. Only question is,
being a common theme.
yes, my lords.
But today, logical discrepancy has not been a category in others. We have examined Bihar and we have found not a single person was flagged on logical.
Millets, West Bihar too has exclusions. Not even a single appeal was filed.
It was
What is the
missing.
percentage of Bihar? The table, you see? Take the table. Maybe I'll agree with you. How come we have missed it? Was there any logical discrepancy? The election control can always manage the problem that applies. We have 45 deletions. How come you are this side? What is happening? Yeah, that's what I'm. Give it to them. Saturday morning, 35,000. Today morning, you can something.
Notices and no hearings in logical discrepancy cases, which is not correct. Notices will come, issue, they receive hearings happen before the ERs. The state of decision making, the creation of system. The council issue, when the hearings did not happen, congratulations. But it's not so that there was no hearing at all. But it is his right that there may be errors. That's why we are also pointing out that there are errors in their decisions. And we are also pointing out things. The tribunal should therefore not be agreed by such kind of petitions. That is all that we are saying.
What are those people who have assisted us? What are they called? Are they still there?
Yes, they are still there. They have been given assistance to the judicial officers. Now that the job is over, they have been deployed in the election duty.
My lords, may I kindly appreciate one thing, my lords?
Work
In
of
all,
the appellate tribunal, it's not a competition of
they have an enormous task now.
conflating the electoral role or deflating the electoral role.
Neither way, my lords.
Ensuring a fair hearing in inclusion and justifying it.
Absolutely. My lords may have seen when there are strange instances, candidates coming over, we have readily volunteered, gone over there and we have done it.
That
In
is
with regard to my lords?
very right and good spirit that.
Yes, my lords. Now it seems there are about 25 to 30 lakh appeals to be decided by them.
34.
34 plus, my lords.
On a very arithmetic computation, each tribunal is having over a lakh appeals. If each
Well,
one is.
from day one, my lords, from day one, wherever there is an exclusion or flagging out, we have put them on notice and micro observers have assisted the EROs and later the judicial officers and at arriving at the just conclusion, then the orders were passed. Only the issue came with regard to the inadequacy of EROs. Otherwise, it was a smooth keel.
By giving that the question of hearing was not there.
Yes.
So in these situations, we may require an
Now
online.
tell us what we
I'm
want.
afraid there was hearing before EROs.
My lords, just
So, like,
during the
yeah,
West Bengal SIR matter
There was.
There's no use of any academic exercise.
So be it.
So we'll see that how the tribunals work and
Yes, my lords.
Your
Yes, my
lordship
lords.
is hearing the
And-
West
and
Bengal SIR matter
If I,
to my
if I
lords.
give
today.
the order passed by Justice Sivagnanda, my lord, your lordship may kindly read
we
matter
will
two
not
during.
mention any
I-
SME which should be very clear because it will.
No, the other matter, my lord, your lordship want me to continue the argument with that, my lord, or should I conclude it here and now?
No, here there is no question of we will not enter.
No, I'm not, if an impression is given, my lord, that I want to score a point and come here first, take an order and run away,
Today
that's not
you
the
have-
point, my lord.
Still half day working.
Yeah.
Instead of getting an order in the evening,
Yes.
better you pursue your appeal there.
No, I'm not saying
Make
that.
out a case of urgency before the tribunal.
So if your lordships, my lord, are under the impression that I've come here to get an order from your lordship, run and score the match over others, it's not that, my lord. I come here, my lord, to say that, my lord, till the 5th, the venue, my lord, was not established.
That
There's
is
a,
indicated to you.
no, so if the ECI comes up and says, my lord, that first, second, we did everything, there is a letter by the registrar, my lord, of the High Court saying the venue is not available.
You are more concentrated on.
No,
this
not.
side.
I am now on para 9, then your lordship may see page 103, my lord. They say, my lord, that the judicial officers, my lord, have worked backwards. You see page para 9, my lord, at page 103.
Anybody will try to target the judicial officers, it is not acceptable.
Nobody is targeting anybody.
But once the documents have been scrutinized,
If the documents have not been scrutinized, the High Court Chief Justice says the documents are not scrutinized, there are no reasons given. Kindly see.
It's a
page 9.
wild,
The High Court Chief Justice says that there are no reasons by the judicial officers. Para 9, your lordship's order.
Let them pass an order.
So
They are not
if somebody
considered.
passes an order saying delete it and without any reasons,
Once the judicial officers have scrutinized the documents, there is a
they
presumption.
have to give reasons. They have not given, the High Court Chief Justice says they are not giving any reason. I fear. He says, I fear it.
Disrespectful like this.
My lord, I
They
am
have done
saying,
a commendable job.
they have not given any reasons. They have brushed everybody's side is my submission.
They have done it.
They could not have done that. The High Court Chief Justice says at para 9, the issue of alleged non-availability of reasons for rejection of the objection by the adjudicating authority, namely the judicial officers, is also highlighted by the learned Chief Justice.
Millets, they've been
And, that,
given an
and this is the
opportunity
what
to file an
Justice-
appeal and to
before Justice
vindicate their
Srinivasan,
stand.
in that particular
They've been
matter,
given an
they didn't
opportunity.
give the reasons. Just
Let's-
read that order. Read
that-
para 9 with what Justice Sivagnanam says.
Since the petitioners have already.
It is very unfortunate.
Before the appellate tribunal, comma, we are, in our considered view, the rest of the apprehensions expressed in this petition are premature. It goes without saying that if the petition's appeal is allowed, comma, the necessary consequences shall follow. It's like, if necessary consequences shall follow. The petitioner, comma, if so advised, may therefore approach the appellate tribunal before whom their appeal is listed and make out a case of out of turn hearing. It is explained, we clarified that we have not expressed any opinion on the merits of the case.
That is what they're doing.
Manoj, may I have
Millet,
your?
this is very
Manoj,
It is not unfair.
may I have your?
Yes, yes. When you are frustrated, you don't have a point. The only thing is showing the lung power and accusing others.
This is the appellate tribunal. Both sides, you produce the documents and reports. We have already mentioned our detailed, despite detailed order. There is no question of now arguing here.
Manoj, I am seeking your lordship's
We are
leave.
coming back. We are coming.
Manoj, I wanted to mention item 59 for Manoj, if your lordships may take it now.
Item?
That 59, this is that unfortunate POXO case, Manoj. And
yes,
the
yes.
difficulty is the commissioner is here and there's some law and order issues, Manoj, which are brewing.
Told in the morning, yes.
Yes, Manoj. So would your lordships take
No, no,
it up
please
now?
go back. We had, Oleg, send them back.
Please, Manoj. So commissioner can go back?
The instructions.
I have the instructions. I have the certified
Understood.
copy of the file, Manoj. The ACP and SHO will stay. The commissioner may go back.
My lord, before, in that very matter,
Minister's Matter Act Civil 46 was specifically today at 10 PM for final hearing a lot in the afternoon. It's a foreign award passed in my paper about 100 crores. I have subsequently.
What happened? Abhi karni hai ite.
Today at 2 PM, the lordship are busy in the afternoon. But they in the first week of January.
I don't appreciate this kind of interference.
my lord is,
part of the Supreme Court members of the bar, we are broadly using the word.
Yes.
I think that SCBA also very graciously themselves.
Scora
So
also.
I think your suggestion.
Absolutely, my lords.
We have just come here
We
to say this,
welcome it,
we leave
my
it to your
lords.
lordship.
We welcome your lordship's decision on this.
May I also be permitted minutes? May I also be permitted minutes to assist minutes on 1 point minutes? If,
If and but see,
with permission minutes, just one small issue minutes, if
there is no need, you can tell Dr. Menka, or tell Gaurav whatever you want to say.
I am for an interview. Minutes, I am an advocate on record here, minutes, I have been a former member. Minutes, just two aspects minutes may consider when, one is minutes, whether this petition, as it is filed, it is asking for representation on the basis of exclusion minutes.
We know that you are opposing in the name of suggestion.
I am not, minutes, not at all minutes, not at all. In fact, I welcome minutes, the step the SCB and the bar councils have taken minutes. These are the important issues minutes because advocates on record are a separate class minutes because the
All right, thank you very much, thank you. Now tell us, which are the the one is president, then you have vice
Page
president.
38, Lordship, page
Yes.
38. 38 have all the posts, Lordship may, whichever two posts and 1/3 of the executive members. Lordship have page 38.
Why don't
Yes.
we four of you just discuss? Dr.
Yes.
Menka.
Yes, my
and,
lords.
You,
Yes,
Gupta, you and Gaurav, all of you just
Yes,
discuss.
Yes.
and,
Yes,
we'll do that. We'll do that.
So two posts and two members from the executive minutes. So whatever Lordship may just decided to us.
Whatever my lords decide.
Whatever your Lordship said, we are all on the
Welcome it, my
same page.
lords.
Minutes.
We welcome it. We
Yes.
want to see some change, so
Absolutely.
welcome it.
Whatever your Lordship think fit is proper minutes.
Yes, always, my lords.
Yeah, what should we do? We have secretary,
Secretary, yes.
Yes,
so we can go for secretary.
Secretary,
very
yes.
well, my lords.
And we have very, I think all of us have very pleasant experience of
Pragya,
Pragya. She has done a very commendable job.
amazing, yes.
Absolutely.
Amazing, yes. So secretary can be one, it can be treasurer or joint treasurer, whatever your Lordship.
As your lordship sees fit, my lords.
Dr. Menka, you were saying something?
No, my lords, as your lordship sees fit. Secretary, treasurer, maybe, both positions.
SCB is started with treasurer. SCB is started with treasurer.
One or only two?
Two will be better, Milos. It may be that they will normally get elected also, but
Then joint treasurer can be.
right,
Very well, my
very well,
lords.
Milos.
Very well.
Very well, Milos. And two posts in the executive members.
And two executive.
Yes, Milos.
Say the issue pertains to ensuring adequate representation to women advocates on record in the composition of executive committee of office leaders stroke executive committee of the Supreme Court Advocates on Record Association.
I don't know that they will.
Both sides have graciously and fairly, on our suggestion, I agree that in the ensuing election of Sura, the post of secretary and joint treasurer and two executive members may be earmarked for representation of the women advocates on record.
Milos.
When say invoking our powers under Article 142 of the Constitution, be ordered a court.
Milos.
Now we are happy.
The time they
We
will
are
be
happy now.
minutes,
sir,
the larger issues were involved minutes because then minutes may also would have considered at the level of entry also minutes. The question of, these are the larger issues in context of only AOR's minutes I was submitting.
All right, all
As
right.
I'm saying whether there's a
As minutes
requirement to
speak.
extend the time or Scora will be able to do it in this time
The
frame.
schedule remains the same.
They can do it.
They'll do-
Remains
all-
the same. There's no problem, my lords.
All right.
Ministers can be-
Yes,
Yes, yes.
absolutely.
Nomination is anyway
Grateful.
starting from 15th April
So-
until
Yes,
20th.
no difficulty. I just wanted to inquire. Grateful to your Lordship.
No problem. We're also very grateful, my lords.
Thank you
Yeah.
very much.
If you
Thank you.
Obliged.
Lords, 57, my lords, I'm only aggrieved with the non-grant of stay insofar as the proceedings are concerned, and I'll tell you lordships why.
Item 57.
57, my lords. This is non-grant of stay, my lords, is my only worry, and I'll tell you lordships
What?
why.
We shouldn't entertain this kind of.
No, I'll tell you lordships why, my lords. Lordship may kindly see, after the FIR gets filed, there is a closure report that comes to be filed by the CBI. While, my lord, setting aside the closure report and order further investigation, lordship may kindly see what the order passed by at page 206. Lordship may kindly see. 206 says, my lords, that insofar as this entire final report is concerned, it does not say and it does not adhere to the order passed by the High Court while transferring the matter to CBI, which says, please find out the gamut of the so-called scam insofar as the number of people who could be victims. CBI makes a specific, my lords, government saying that we could not find any single victim insofar as this company or the scam is concerned. My lords, the chief,
The state of Mizoram is the biggest victim.
my lords, and that,
The state of Mizoram is the biggest victim.
my lords, and my lords, that is the
Your public
Don't invite
servant is
observation.
swindle away the name of the state to permit a criminal to perpetuate multi-level
My
marketing.
lords, but that is what the CBI says has not happened. When it filed
You
the
want us to write all these things in the order.
no, my lords, I am only requesting, my lord,
Frivolous petition dismissed. The moment we will write 2 lines, it will become problem for you.
Lordship,
Yes,
I have
just
compiled
consider-
a brief note for your lordship's perusal. Madam, I would request you to please pass it on.
See, Mr. Diwan, probably you were not there last time. There was just only very preliminary observation, we will say. Not prima facie, only preliminary observation. Now this IRP is under cloud. Whatever may be good reason.
I have nothing to say on that, but I have something to say on the other aspects. Because we received a copy of the report, which was made only on Saturday. And this Saturday, after the order came to be passed, we were not aware of the application being made, etc. So I am just, I don't want to get into it. First of all, I have indicated to, as far as my client is concerned, I'm not saying anything at all as far as the IRP substitution is concerned. Please go ahead with that, because if there's a genuine problem on that. But on the rest of it, we have something to say, which is why we filed an application for, which we've served on the amicus, for recall, so that your lordships can then adjust the equities, etc. appropriately. So I'm suggesting, I mean, we can do it today, but if they want some time, then on with regards.
Response is ready, you can give, we can keep it.
Yes, yes, I have a submission. This is my recall.
Then we may examine this response also.
Do that.
Can I take 1 minute, my lord? My lord, we are appearing for one of the banks, IFC. I'll just take 2 minutes. My lord, your lordship's earlier order classified the entities into 2 broad buckets. NBCC, unfinished projects as 1 bucket, and finished projects as another bucket. We are a case where, my lord, our project is completely finished. It is operational. It is functional even today. And there is a default. We don't have any problems of construction or a home buyer, nothing. It's all working. Only problem is default. So, my lord, this is, my lord, as originally conceived, a separate CRP, CIRP, or whoever can be occupied to do it. I'm the only financial creditor. I hold 85% stake in the COC. So, what has happened? Earlier order, your lordship directed us to go to NCLAT, which we have done. Our IA is coming on Friday. But day before yesterday's order, my lord, please see 1 paragraph your lordship may see. Paragraph 4 and paragraph 5, which, my lord, if we can show only one suggestion, very respectfully, your lordship's kind consideration. If your lordship sees paragraph 4, may I read only paragraph 4 and 5, my lord. Although, as this is pointed out by so-and-so learned senior counsel, the IRP has challenged the suspension order before the Delhi High Court. It seems to us that the projects, meanwhile, must be completed under the court-monitored action. Proprietary demands that the IRP, till he is fully exonerated by the court or any other prescribed authority, should distance himself from the ongoing proceeding. I am appearing for the IBBI in the Delhi High Court against this IRP.
At your instance, that
Yeah, and we have filed an appeal before the Delhi High. They filed a we have responded. We therefore find merit in the recommendations made by the learned amicus that a court-monitored mechanism be adopted to ensure the completion of projects by NBCC takes place without any hindrance. Paragraph 5. At this junction, we hasten to note that there are approximately 30 projects undertaken by the company in question, out of which 16 have been entrusted to NBCC for completion by way of judgment dated 12/12/2024 and order dated 5/2/2026. In our considered opinion, the issues relating to the remaining projects also ought to be administered within the same court-monitored framework. Accordingly, the underlying policy with respect to all projects, whether fully completed, substantially or partially completed, or which are lying incomplete and inactive, including those which have been handed over to NBCC, shall be determined by a common authority that may be set up by this court. Not 5 of them form one cluster. There is no difficulty at all. Substantially, partially, incomplete, or inactive, they are all form. Our projects are totally completed and it is operational, it's functioning, and yet default is happening. So we are moved an IA before, as per your lordship's previous direction, earlier direction, we have all been asked to go to the NCLAT to fight our rights. We have filed our IA. It's coming up on Friday. So can completed projects alone be taken out of this list? One of them, my lord, they form a one class. There is no difficulty.
No, we have something else to say, because if it was original appeal was confined to 16, our respectful submission is that it ought not to be expanded to 30. I don't know what he might, I'm not for a moment opposing what is being suggested just now. But suddenly from the scope, because the balance 14 projects are pending before NCLAT. They are pending, they were not the subject matter of the original appeal.
This was only during the course of very brief hearing.
Yes, brief. Yes.
This was our idea, because if 16 projects under a court-monitored committee continues and those projects are completed, or the home buyers in those projects are to their satisfaction able to achieve their and the other projects are maybe that's why we use the word partially incomplete or substantially.
Correct. But please hear us on this, because it was not the scope. Your lordships disposed of the appeal. Now everybody is before NCLAT.
I'm appealing for the home buyers, Millard.
The MA
Appealing for the home buyers.
Millard,
2011.
I take serious objection. The MA ought to have been served on every party. That's the least which the amicus curiae must do. The second is that at least he must serve us a copy of the report. Without having a copy of the application, no notice served on an MA, a report filed, served on me after the order is passed. Your lordships have used the expression, in fact, over here, which speaks about propriety. I would respectfully submit that propriety at a minimum requires that in a disposed of case, when a miscellaneous application is filed, at least it must be served on the parties along with supporting documents. That's the least.
No, supporting documents is, it's not, everything is admitted on record that IRP has been found guilty of something.
No, it's not, Millard, I'm sorry.
Placed under suspension. Now the committee which has been looking after the Apex committee is headless. All these are a matter of record.
I have no problem with that. I started by saying that, look, if there is some practical difficulty, in fact, what ought to have happened in a situation is go to NCLAT and get it substituted by NCLAT. How do you, in a disposed of appeal, come over here, file a report, don't serve it, and secure an order like this, which is a tremendous variation?
No question. You see, amicus has no interest in the matter. There is no question of any securing order by him. This order is only because he pointed out this suspension part to our information.
So that may be retained, my lord. Para 4 may be retained.
By virtue of the approval, we granted to that order. Therefore, because by virtue of an order passed by us, if a person whose conduct, unfortunately for any reason, is under cloud, that's why I said that there has to be a court monitor committee.
So, my lords, on that I started by saying I have no problem, but please confine it to para 4.
Yeah.
Only to 16 projects.
Lord, may
Consider it.
Yes.
Yes, we
May
don't
just
projects.
make one
No problem.
There is
I appear.
a submission, Millard, for the home buyer. The submission is this: we are equally placed, other than 16 project, Millard, and these projects are also 2010-11. They are incomplete, and your lordship had rightly said.
That part.
Yes, Millard. Grateful.
Our query was that in 16 projects which we are giving to suppose the court monitoring committee, those projects will be completed. Part of the home buyers will be happy. Rest will be again making.
Exactly, Millard.
But on that,
Propose
problem,
that
my lord.
we support it, Millard.
That there's no problem. 16 was what the scope of the original appeal is. If someone wants to increase, your lordship appointed the amicus to assist the NCLAT proceedings. Now, over there, we will have our day in court and we will assist over there. So any variation to be done because of exigencies, etc., can certainly be done before NCLAT. But suddenly to come over here, expand the scope beyond the original appeal.
NCLT is not going to regulate our proceedings.
Correct.
No, of
correct.
course not. But your lordship disposed of the appeal.
That is the court initiative only to bring
Other than,
kind
other
of
than,
parity among all the home buyers
correct, correct.
and to ensure that some of them do not feel that they have been left behind.
No, those are
And are
complete
equally
projects.
placed.
These are delivered projects, the other remaining projects.
Complete projects where everything is complete.
Yes.
No, they are not completed projects.
Yes, my case, one minute, don't mix up.
But
But
I
in my
have
case,
one
I
thing.
say, I can say it on an affidavit, complete project.
We find a merit even in complete projects. Suppose the financial institutions are yet to recover.
Yes.
Now,
No, so that can be worked out before the NCLAT, because that issue which your lordship is correctly placing before me is actually pending before NCLAT. NCLAT itself had 17 on one side, out of which one is completely complete. So that was not part of the 16 which your lordships held. And then you had the balance projects. That issue is under consideration of NCLAT.
that said, that may not be a ground for us not to now to just ignore the ground reality that's going to happen.
There is
If
There's
suppose
no
that
ground reality, my lord.
IRP was there, then this issue was not there. Because IRP was there and it was IRP for the entire company, for the entire entity he was there.
No problem, my lord. You can, as I said,
For the
if there's a
16
substitute IRP, we have no problem with
No
that.
problem.
Lord,
We have no problem with that.
may I just bring one fact to my lord's notice? Just 1 minute. Lord, a financial creditor in relation to the 16 projects, my lord, where the apex court committee was constituted and where your lordships, my lord, have noted that IRP is now suspended. Lord, we appear for the financial creditors. The composition, my lord, that was determined by NCLAT, which your lordships found favor with, was total 5-member committee, IRP who now goes out. There are two largest creditors. One was NBCC, fourth was an independent person. Lord, all the other persons are still there. Lord, this committee has done considerable work. Instead of having, my lord, a completely new committee, if the IRP goes out, any judge or any person your lordships thinks appropriate can replace the IRP.
We will appoint an independent committee. Some of the other, the ACC, there is an apparent conflict of interest also.
Apex committee.
These are there. We have
But
to-
then I have only one request. If your lordships are inclined to appoint a completely fresh committee, my lord, my only request is, like your lordships were pleased on the last occasion to give representation to the creditors. Your lordships gave us 2 seats, my lord, out of 5. My lord, I am requesting, my lord, that your lordships may, my lord, appoint any new committee will be with your lordships completely. I am only praying, my lord, let the financial creditors continue to have that representation.
And the home buyers also.
I have no difficulty.
You see, financial creditor, in any case, their interests will have to be protected, and I think earlier orders are there adequate enough. We can.
My lord, only thing that
certain
happened.
All directions, we can.
Only thing that happened, my lord, in the committee, my lord, as proposed by the learned amicus, which is, my lord, following what happened in the subsidiary matter. My lord, none of the creditor representatives are inside the committee. So what happened is all our suggestions and inputs are now externalized. If you are a part of the committee, my lord, when the committee itself is considering, there will be an internalized input that would come.
Of our experience of appointing independent committees in some of this kind of projects has fortunately been quite satisfying. We will not say that it has been very really outstanding achievements, but wherever in certain other projects, such committees have been constituted. At least home buyers' interest has been adequately.
Correct, correct.
Financial institutions' interest has also been to some extent protected. And there is at least no sense of insecurity created as far as their interest is concerned. So we are quite.
Lord, my lords are right, but if you may just bring to my lord's notice, just a minute, serious.
May I
Lord,
make
if
a
you may bring to my lord's kind notice, what happened is, my lords are completely right, my lord, I respectfully bow down. But in some of the committees, my lord, what happened is where the creditors' inputs were not considered at all, there are litigations now coming before this honorable court. All that I am requesting is, lordships may have home buyers representatives, if, my lord, that is a request that is being made and if it appeals to my lords. My lord, your lordships may only provide, unlike the Supertech realtors, my lord, where none of the creditors' representatives were on that particular board. Lordships may kindly have representation from the my lord, creditor side also, like your lordships were pleased to do in this very matter on the last occasion.
That part, once we constitute the committee, will pass an order in open court only.
Because, my lord, para
I think
6,
that Mr. Diwan has filed some objection, Mr. Jain, you may consider those.
in para 6, just a minute. My lord, in para 6, your lordships were pleased to.
Completed projects are.
We filed a recalling.
Electoral and the submissions, because we have traveled substantial
Certainly good.
distance. Most of us we have taken.
The word substantial creates problem.
No,
If you say.
We are seeing full, I'm saying full. It is operational. It's working and they are defaulting.
If you say the.
In spite of working, they are defaulting.
We will happy a statement if you say project complete, home buyers possession delivered, financial institutions paid, transfer, sale deeds have been executed, conveyance deeds are.
Share deed registration, share deed.
Yes, we are very.
But in my,
What was that
but in my case, no home buyers are involved. It's a mall cum hotel, completely functional and they are defaulting. Therefore, my lord, can I move an IA? Might be permitted to move.
Because the details of all those projects.
Yes,
are very-
we'll keep it.
Like to.
Maybe.
Yes,
Yes, have to examine.
Lordship, in your order dated 5th February, your lordship, para 20 states that the amicus may approach this bench in case there is any impediment to the implementation of your honorable court's order. Consequently, once the IBBI passed the order against the IRP, there was an evident impediment in the implementation of this bench's order. Hence, I move that petition. At the same time, your lordship, you need to factor in this, that Supertech is a legal entity registered under the Companies Act. It's a corporate debtor. It not only has projects, it has other things. It has investments, for instance. It has subsidiaries, over 24 subsidiaries. It has litigations. It has relational party loans and transactions. All those would need to be taken care of by an entity. Currently, what do we have? Currently, in the absence of IRP, we have nothing. If we agree to the proposition that it is only, if ACC is only for the 16 projects, then who looks after the rest of the company? What happens to the surplus of non-16, or say a receivable from a subsidiary? Who manages the boards of the subsidiaries? There are issues which the company as an entity has to handle. There has to be a credible body like the board of directors discharging the functions of the board of directors. If not ACC, then who? So in the current dispensation, there was no COC, sir. And if ACC is only looking after 16 projects, then who's looking after non-16 and rest of the company? Only the IRP. I'm sure that was not the conception of the honorable bench. So the company has to be looked after. The company's interests go far beyond 16 projects. And home buyers we need to put in a structure in place that protects the interests of the home buyers, and then the lenders and the authorities.
Anyway, we'll put in our objections in 3 days' time, and your lordship may list it next week or whatever.
Others also you can give your.
Yes, my lord, we will also.
But even on the composition, my lord, we'll place our submission.
Take it on next Monday then.
Yes, very well, very well.
But even on composition, my lord, we'll place our submission. Your lordships invited it at para 6.
Your lordships,
Lordship, may I make one request?
Can it be next Friday, my lord?
Lordship's notice, just that I may failing in my duty to inform that there has been an amendment in the code, my lord, on 5th of April, 2026. And the new guidelines have come on 7th of April, 2026, which the amicus is not aware of it, and probably he did not inform to the court also, my lord. Lordship may appoint the IRB, but that amendments have to be taken into consideration because it has now come as a project-wise, my lord, not independent, not as a composite, my lord. And somebody in grieved out has to go independently to the NCLAT, my lord, not like in a cluster. My lord.
Lordship, project-wise committees have not been formed so far.
This is the amendment, my
In
lord.
the NCLAT's order of December 24, the project-wise committees also had a role in finances, because the NCLAT stated that the ACC has to conform to RERA regulation of apportioning the funds into 70-30 ratio, wherein 30 would meet the dues of the lenders and the authorities. However, this honorable bench ordered that first, the project has to be completed, home buyers' interests have to be met, and only subsequently the surplus has to be diverted to pay the dues of such and such. Now, so the project level committee no longer have a financial role, and the project level committees have not been
To
constituted.
have a separate committee for each project because.
At the same time, sir, since projects are spread in different places and the lenders are different, the home buyers are different, in some cases the authorities are also different. And the Apex committee may not be physically capable of supervising the implementation of the NBCC project at all the places or monitoring the grievances of all those projects. Consequently, some kind of a structure which maybe the ACC can think of or someone else, that some kind of thing needs to be there at the project level to handle the project related issue, except for the financial part.
Lord, may I
Can
bring
it be on
the-
24th, my lord?
May I bring the notice to amendments?
Suggestions, if any, to the proposal, to the recommendations made by the London Micros,
Amendments.
which are duly incorporated in our order dated 10th April 2026, may be made within 3 days. Post this matter for further consideration.
Can it be on 24th?
Submission.
24th or 27th, my lord? Home buyers have to file also.
Next Monday, because the urgency is there.
My lord.
Yes, yes.
There is, nobody is working and we have stopped, there is an entire order.
Yes, and my lords, may I, that I've handed in an MA, that may be registered, my lords. So I'll put in my replies also separately.
But I have passed on the amendment also, my lord.
And I may be given a copy of the MA.
Section 526. Next please, 526.
Yes, please pass. What do I know?
I have passed on the amendment, my lord, for your lordship, please.
Right, we'll consider them together. You give to the amicus.
Yes, we. Amicus.
But should that MA be numbered? Which we have, I have taken out an MA with E-filed, etc.
You ask your junior to file now in the registry because.
Yeah, no, we'll file in the registry. They say that because it's a disposed of appeal, they don't number it.
Permission would be
Without your permission.
Permission would be required, my lord.
The registry director to assign the number. Post this, I may on the date.
Grateful.
Pension may be allowed.
My lords, I beg to appear for the state, my lords. The file and record is here. We filed a status report. It may not be on record, my lords. I'm carrying copies. My lords, broadly, if your lordships will see, my lords, the charge sheet is actually filed under the enhanced sections, my lords, of POCSO. In fact, the enhancement happened on the very next day, my lords, after the inquest report and postmortem. So we are carrying, my lords, your lordships had permitted the commissioner to go back, but the, my lords, ACP, the SHO are here. Original files, because the charge sheet has been filed and cognizance is also taken, my lord. They are with the,
That is what is happening, and sometimes it's quite disturbing that suddenly somebody wants to come to the court. Then you say the charge sheet has been filed.
In this case, the charge sheet was actually filed even before they came. So the date of the charge sheet here is, my lords, 3rd of April 2026. So on the writ petition does not disclose it, my lords, but the charge sheet was filed on 3rd of April 2026 and cognizance was also taken.
My lord, I have certain things to say. If you see what the status report which has been filed, on the last date of hearing, I had submitted specifically that there seems to be an attempt to shield the hospitals concerned. One, they have not served the hospitals despite your lordship's directions. They are yet to come on record. Secondly, you will find that the policemen have gone around, recorded statements of people saying this, that the child was found not breathing at that point of time. The video is speaking otherwise. Why don't they inquire into that? An SIT needs to be constituted because there seems to be a concerted effort to see to it that this is completely taken away from the record. Even now, despite the fact that there were directions from this court, and even the postmortem does not direct an inquiry towards the aspect of sexual assault. This is the manner in which these investigations have gone on. One can really.
Charge sheet has been filed under which provision?
Please, my lord.
Have you mentioned any charge sheet?
The charge sheet I have yet to see. They are yet to file that record. I'll have to look into that. But the status report which they have served on us.
So the status report, your
We've
we've served the hospitals also.
Murder.
Lordships will see para 18 of the status report, my lords. The charge sheet has been filed
Respondent 4, my lords.
under section 66, which corresponds to, my lords, section 376A, 5 and 6 of POCSO Act, which is aggravated. Lordships will have para 18, my lords.
And murder and.
No, my lord. Here the issue is that when the child was alive, 2 private hospitals have the discretion to say that we will not treat you, we will not admit you,
That is not a.
and the child dies thereafter.
That is not a part of prosecution.
No, that is also a part of it.
That's not a part of prosecution.
But what I am trying to say is, my lord,
Your main thrust will be against the offender who has.
no, that as well. As far as the offender is concerned, when the FIR came into place,
In the nature of, I think 357B. of
no, my
the
lord.
old code.
Here, in fact, offences independently are attracted against the hospital in relation to 304. Because at the time when the child was brought there, if that aid was given at that point of time, the child would have survived. You, in fact, hasten the death of the child by not admitting the child and giving that child the treatment at that point of time, especially when there are directions from this honorable court that nobody can refuse. That is what is also bothering me. We have lost a life, and especially our 4-year-old child, because that medical intervention didn't happen.
We have,
Not one hospital, 2 hospitals, one after the other.
we have penal provisions.
Apart from that, there are penal provisions in relation to that.
We have penal provisions for the failure to record a report. Record a report at the police station in respect of a sexual crime.
Even that was not done. If your lordship sees,
Now, hospitals will not record it, right?
no, I am not saying that.
Just examine according, in light of your submission, which is quite distressing that the hospitals did not extend medical relief, and that would be a breach of Article 21 rights in the form of a constitution tort. Whether that would.
No, it would not be a tort alone, my lord.
That is what we should expect.
In a normal case where it's a
Whether-
situation,
Whether this would transcend to crime.
yes, it would.
What would be the offense according to you? 304.
I would say 302 at the highest, but 304 at a lesser degree. Because you are fully aware of the fact that there could be a situation where the child may not survive. You have that knowledge. And the police shuts its eye in relation to that, records statements contrary to the situation in the, I will only urge one thing, my lord. Your lordship may kindly see
The prosecution should be against the principal accused.
the principal accused also, my lord, initially was to shield him.
Penumbral players.
I agree to one aspect, my lord. As far as that is concerned, even the FIR, initially, if your lordship sees the FIR doesn't talk about rape at all. Where is that?
Lying last seen together and the recovery.
My lords, last seen together, there is also.
Any, you've sent the blood and the other
Yes, my lords.
fluids for DNA examination?
Yes, my lords.
And also of the accused?
Yes, my lords. The
That
report.
whether any bodily fluids of the
Yes.
accused found on the
Yes,
body
my
of the
lords.
deceased?
Yes, my lords.
If your lordship.
There is one more additional.
These are the areas perhaps which are.
My lord,
There is
there are
more
2 areas which
focus
are
to be
disturbing.
given, rather than, we understand your concern as a bereaved parent. But if you look at it from the perspective of investigation of the crime, it should be targeted more against the person against whom the allegation is one of murder and rape. And the clear investigational purposes.
Now, my lord, shall we look at it from that dimension?
Mr. Hari,
I will take you through that dimension as well.
Yes, that is.
My friend is saying that everything was done. Kindly see that the incident happens on 16th of March. Till 17th of March, 3:30 in the morning, the next day, around 18 hours of difference is there in even getting the first information report in place. And what does my friend, can I?
3:30 in the morning, my lords. It's not.
3:30 in the morning is what I'm saying.
It's 3:30 in the morning.
Incident is happening at 6:30 in the evening. The aspect of the child having been brought dead is recorded at the hospital at 21:55 hours. Why is it that the FIR is coming into place at 3:30 in the morning, my lord? Look at the time period which has elapsed. And the FIR which is coming into place is an FIR which is coming into place only in relation to 302. There is no mention in the FIR of any of the offenses of aggravated assault or in relation to rape, which is what I pointed out on the last date of hearing.
Sorry, I was just going through the status report.
Please, your lordship.
We better just examine the charge sheet,
Very well. Let them,
because we would first like the victim's family's full satisfaction. The law will never be able to really, to our satisfaction, its movement will fall short of unless the victim family is satisfied. So, but at the same time, in our over anxiety, constituting SIT may unnecessarily may not further delay the proceeding. From that angle, you just examine.
My lord, I have only two concerns. One, the day the report is tried to be lodged by the father, he gets beaten up at the police station.
See,
A daily wager, a laborer, this is the manner in which they treat him.
that's why
And now they are hounding him, saying this, that you have gone to the Supreme Court, please withdraw your petition. This is the manner in which he is being treated.
Did he receive this sort of a threat?
Yes. And he has been shifted from Uttar Pradesh to Delhi now.
the trauma and torture the family has undergone,
Please, my lord.
the trauma, the torture,
Yes.
the agony, and the kind of this pain.
The child and the hospitals don't treat the child, my lord. How can we in a country like ours even imagine a situation like this?
That's why we want that first of all, because they know everything that how the occurrence at the entire.
Why aren't they accepting the video recording, my lord? There is a video recording of the child where the child is seen to be alive. Why don't they take it on record?
They are referring to a video recording also. That's why we are just pointing out.
It's right here, my lord. I can give it to you. I can pass it across.
They are referring to some video recording. Is it the same thing or is it different
Of
thing?
my child, my lord. I am carrying my child.
Please examine it. You are the best, with the assistance of the parents.
But my lord, they should first and foremost take that on record. They refuse to take that on record. They are going by the assumption that the child is dead at that point of time. That is the whole problem. And my friend says that no, everything is okay. Nothing is okay, according to me. It is highly disturbing, my lord.
Please try to understand what we are trying to do.
Yes, my lord.
Now they are coming out with a charge sheet which refer to some.
I will
video-
look into that, my lord. Tell them to give me a
some
copy.
video recording, etc. They are referring to. Which video recording are they referring? Is it the same or different, or is it only a?
I will have an examination of that.
Only a kind of a, just to.
An eyewash. Your lordship, I tell them to give us a copy. I will look into it and I'll get back.
Just examine. As a victim, you are entitled to a copy of charge sheet. You go through it.
Very well, my lord.
After that, if you feel that there are some gaps which have been deliberately left or because of their negligence it has been left, we would like an SIT to examine.
Very well, my lord.
But if suppose charge sheet has been filed, then there is a different kind of monitoring required. Then we will evolve that mechanism.
Very well, my lord. I will assist you on that.
But
I will
that
assist you on that.
That we are exonerating the hospitals or.
No, I'm not saying that. My only.
Those issues will be separately examined.
Very well.
We are not closing the issue.
Very well, my lord. My anguish is that a child is not getting treatment when the child is in this kind of a state. Maybe the child would have been alive today and we would have had better evidence. We have to look at it from that aspect too.
Now, where are the two hospitals?
Yes, I am representing respondent 4, my lords. And Joseph.
Lordship, I'm appearing for R3. I'm appearing for R3, Your Lordship.
R5,
R3, Your Lordship.
R3. That's it. Say in corporate compliance of order dated 10th April 2026. A status report has been filed. Is it signed by someone?
The additional commissioner of police, my lords, at page
Each page is.
21, my lords.
Has been filed by some assistant, has been filed by an assistant commissioner of police. Police commissioner, Ghaziabad. The status report revealed that charge sheet has been filed. Before adverting to the various issues that we have briefly flagged in our order dated 10th April 26. We direct the police authorities to supply a copy of the charge sheet to the victim's family.
Along with that CCTV, my lord, which they are, the coverage that they are saying. So that I'll be in a position to compare. Because my reading is that it is a CCTV of the location which they are trying to show.
That's right, my lords, it's the CCTV.
Yes, so it is not that video recording which I'm trying to give to them. Why aren't they taking that?
If there is any recording available with the my lords complainant, we can do additional.
He has been trying to give it to them from day one. They are refusing to accept it. This is what I'm saying.
There is a CCTV footage.
Yes, my lord.
Which they are relying upon.
That CCTV footage is, my lord, at the time when they went to the site.
Which
It is
was the accused taking the victim, my lords?
The accused has gone and effected a recovery where they shoot the victim on the accused on his legs. It is of that period that they are trying to give. But this relates to the time when the child was recovered and the father had taken the child from there on a motorbike to the two hospitals.
Accused of
Look into the documents and electronic material they supply to you, and then you make a response to us.
Very well.
So that.
Very well, my lord. All I am saying is let them give that CCTV record to me.
Yes, madam, you can also look into it and
closing
assess.
I agree.
If necessary, further investigation can.
Well, that's what I'm respectfully submitting. If there is anything additional, we will carry out additional my lords investigation.
Victim's family. Post the matter on so date for further consideration. Meanwhile, the first number 3 and 4 hospitals are also directed to file their respective affidavits. In response to the allegations made against them. No further reason in this regard, no further time shall in this regard be granted. Post the matter for further consideration and so on. So
My lords, would your lordships desire us to carry out further investigation on material that is supplied by?
No, who will carry out that further investigation is the.
That is the issue.
So your lordships, we'll hold our hands, my lords.
That we have exonerated them, their conduct is
I bow down, my lords.
under serious doubt.
I bow down.
We have serious doubt on their bona fide, the way they have acted. But today we don't want to comment because it may, unfortunately, if we commented anything and charge sheet is found all right, then it may prejudice the party. So therefore, we have to be very careful in observing anything.
So my lords, we'll hold our hands now, my lords. So my lords, we'll hold our hands now. Whatever investigation we have done so far, that we have brought the certified copy of the file, my lords. Otherwise, if your lordships desire the original file, it will have to come from the court, my lords. The court has given us the certified copy. Otherwise, court has taken cognizance.
No, we are not insisting on the original file. You can give us a certified copy. We have no issues.
Yes, to my colleagues, I'll give copy of the certified.
Give us a
Please.
copy of the certified. That is good enough.
Title to these.
Yes, my lords, they could have taken it, my lords.
No, I happen to be the complainant. The entitlement is to the accused.
No, entitlement is to all. We've supplied copies for you also submitted in.
207 is in relation to the accused, not to the complainant.
We'll give you, sir.
Next Monday.
Next Monday, because I don't think your lordship is free in the